Invoking the private side of common law for a private administrative procedure. Let's talk about it. The public side of common law can basically be invoked by recognizing that each state respects each other's decisions that have been made. What this means is any judgments, decrees, or declarations made in a judicial proceeding of any other state is recognized and respected in any other state. So you can make a decision in Virginia and you can carry that into Florida and they will basically respect it as long as it doesn't interfere with any of their public rules, codes, and statutes of another state. So one state could say it's legal to beat your wife on a Sunday on the front steps of the courthouse. Another state might say you're not allowed to do that. The private side of common law is invoked when you are calling on the private Republican form of government that each state is guaranteed. Now, by doing this in an affidavit form, you have your private administrative procedure, which includes a three-part process. Your first part is called an NOI, a notice of interest. Your second part is called a notice of fault opportunity to cure. And then your final part process is called notice of default declaratory judgment. Now, according to international rules, you must at least allow 10 days from postmark mailing for someone to reply to any commercial proceeding. That is a 3-3-3-1 rule. That means 3 days there, 3 days to read and respond, 3 days back, and 1 Sunday. You must also have realistic requests. You cannot say you have to fly here with your nose hair and bring me $10 million of gold bullion or else I'm claiming that the moon is mine. No, it's not going to work. Send each process through certified mail, not a registered mail because that's a federal benefit, but by certified mail. And you put that number at the top of each page, which basically will marry that public transmitting utility conveyance to that process. And that's a public record, exception to the hearsay rule. Then when you're invoking the jurisdiction, you want to say Colorado State unincorporated, Denver City unincorporated, and then the United States of America unincorporated. Then you want to have your statement of facts. I, the undersigned affiant on the soil, do hereby solemnly affirm, declare, and state as follows. Affiant is at least 18, above the age of majority, and competent to testify. And affiant has first-hand knowledge of the statements made herein, and the facts are stated correct, true, certain, and not misleading. And if affiant is called upon in a competent common law court of jurisdiction to testify, he will attest the same hereto. Then you list all of your facts, boom, 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 and at the bottom you say you must reply in affidavit form sworn to under penalty of perjury to each point, and if any other response that does not meet that criteria will be considered as frivolous. You can say all responses must be sent through this witness or this notary who will be certifying any responses or non-responses. You want to send the green certified card that has a restrictive signature on it so that you can confirm that they have received it. Whenever you have a notary performing their duties and services, you want to put it inside of a box as to not give up any jurisdiction. And then you could also put this at the bottom. So you send your NOI and they do not respond. You certify non-response and then you send your notice of fault. And you basically say, hey, I don't know if you were sick or you were chasing your grandma in her underwear or whatever, but here was my previous record that I sent you just in case if something happened, got lost in the mail. Please respond to this one. So then you send the notice of fault. And then when they default on that one, you send the final declaratory judgment and you basically have a proceedings that is done within about 25 days.